If you are a green card holder, there are still 10 ways you can get your residency taken away from you. And most people don't realize how easily they could fall into one of these 10 methods. And if this happens, you wouldn't just lose your ability to live and work here in the United States. Your spouse and children who got their green card through you could also lose their status as well. And all of you could be placed into removal proceedings. So today, I am going to explain the top 10 ways that people could lose their green card, what USCIS is looking for right now, and what you should be doing to protect yourself. The first way that people can lose their green card is by staying outside of the United States for too long. Now, as a permanent resident, you are allowed to travel. You can visit family, take long trips, and even spend time working abroad. But if you are not careful, these trips can be used as evidence to show that you have abandoned your residency. Here's the rule of thumb that I want you to keep in mind. If every single trip that you take is underneath 6 months, then you will generally be fine. But the moment any one of your trips passes the 6-month mark, even by a little, you can expect extra scrutiny when you return home. Customs and Border Protection Officers, known as CBP, can question you about why you were gone, whether you are still living or working in the United States, whether you were working abroad, where you live, whether you have any criminal charges, and whether or not you consider the United States your permanent home. They can dig into any past criminal issues simply by virtue of the fact that you remained outside of the US for more than 180 days. And once your trip goes past 12 months, the danger becomes even greater. If you did not apply for a re-entry permit before exiting the country, then you may be at risk. USCIS may end up treating your absence from the United States as an automatic abandonment of your green card. And even if your trips are underneath 6 months, repeated long trips can raise questions about whether or not you consider the US to be your home. The whole point of permanent residency is not just to be able to live in the United States, it is making the United States your actual home. So if your travel patterns look like you are spending more time outside of the US than not, or if they look like you don't really consider the US to be your home, then you may expect problems when you return at the border or at an airport. And this matters even more now than ever. DHS has shifted to an AI-based system of tracking your travel movements and patterns. This means that every time you enter or leave the United States, a photo is taken and attached to your immigration record. So if you have been spending too much time abroad or taking too many long trips, this pattern will show up more easily to DHS. So here's my advice if you want to stay protected. Try to spend at least 9 to 10 months every year physically inside the United States. And if there is any chance you might be away for 6 months or more, apply for a re-entry permit before you leave. It doesn't guarantee that you'll be allowed back in, but it will help protect you against accusations that you have abandoned your residency. And this one step can save you major problems when you are at the airport. The next way you can lose your green card is by not having enough ties to the US, even if your trips abroad are always less than 6 months. A lot of people think that, well, I didn't stay outside for that long, so I'm safe. But this is not exactly how USCIS looks at it. They care whether or not your actual life is here. And if they don't see enough proof of that, they can still accuse you of abandoning your residency. So what counts as strong ties? Residential ties, having a real fixed address in the United States, which means either having a lease or a mortgage or living with a family member where you are consistently receiving mail and have your belongings. Financial ties, keeping an active US bank account, having regular transactions, a US credit card, and filing taxes every single year as a resident. Professional ties, having a job here or maintaining a US-based business, earning a paycheck from an American employer, or staying on payroll even during extended trips abroad. Family ties, having your spouse, your children, or other close family members physically living here. If you have school-aged children, keeping them enrolled in US schools is extremely strong evidence. Community ties, things like a driver's license, club memberships, religious involvement, or anything else that shows that your social life is rooted here. If you are missing too many of these, that can be enough for an officer to question whether the US is really your permanent home. So before you travel, make make sure your ties are clear and easy to prove. Because once it looks like you have shifted your life abroad, USCIS can then use this as a reason to take your residency away. Another major way that you could lose your green card is by getting convicted of certain crimes. I want to be clear about something here. USCIS is not going to take away your status over a simple parking ticket or a speeding ticket. But the moment a crime involves fraud, theft, drugs, or harm to another person physically, it can cause problems for you, even if the criminal courts treat these as a minor offense. Some crimes are especially dangerous because immigration laws treat them differently than the other criminal courts do. These are called crimes involving moral turpitude. Basically, anything indicating that you have intended to do harm, including things like theft, shoplifting, fraud, domestic violence, or assault. These can make you deportable if they happen within the first 5 years of you being admitted as a resident, and if the offense carries a possible sentence of 1 year or more. It does not matter. The judge may not have sentenced you to jail, but what matters is what the maximum possible penalty would have been had you been sentenced. And if you have 2 or more crimes involving moral turpitude at any time, even if they happen years apart, these can also get you placed into removal proceedings. In addition, it goes without saying that any aggravated felony is going to get your green card taken away. And this includes offenses such as murder, rape, sexual assault, drug trafficking, robbery, and most violent offenses. These are almost impossible to defend in immigration court, and every single aggravated felony triggers mandatory detention. And there are almost never any waivers available for these sorts of convictions. There are also convictions that most people tend to underestimate, including DUIs. A single DUI can delay your citizenship, and multiple DUIs can result in denial underneath the good moral character rules. Congress is even actively considering a bill that would make even one DUI a deportable offense for non-citizens. It has not passed yet, but shows just how seriously that they are taking DUIs. And remember, immigration law does not necessarily require a conviction in order to render you deportable. A guilty plea, a no contest plea, time served, probation, or certain types of diversion programs can still count as a conviction for immigration purposes. Even expunged or dismissed cases that can appear on your background check can force USCIS to reopen your entire criminal history. So if you are a green card holder and have ever gotten arrested or charged with anything, even something that you think is small, talk to an immigration lawyer before you accept any plea. Many criminal defense attorneys do not fully understand the immigration consequences of criminal convictions or criminal plea agreements. And one wrong decision could put you into removal proceedings and get you deported. Another way that you can get your green card to get taken away is by failing to pay your taxes. This is becoming a much bigger problem now because USCIS is reviewing tax compliance much more aggressively, not only for citizenship, but even when you renew your green card or respond to other filings. As a permanent resident, you are required to file a Form 1040 every single year and report your worldwide income, even if you have lived or earned money abroad. If you skip a year, file incorrectly, or claim that you are a non-resident for tax purposes, this can be used against you as evidence that you do not consider the U.S. to be your home. Now let's talk about the more serious problems. If you fail to file required returns, owe large back taxes, or ignore IRS notices, that can raise good moral character concerns, delay your citizenship, and lead to extra scrutiny the next time you apply for anything with USCIS. And if the government believes that you have engaged in tax evasion of $10,000 or more, that can be classified as an aggravated felony, which means that you can be deported even if you have lived here legally for years. The good news is that you can protect yourself if you handle these issues correctly early on. So USCIS is not looking for you to be perfect, they are looking for you to be responsible. So here is what I recommend. Make sure that every year is filed. If you are missing years, file them before you submit anything to immigration. If you owe money, set up an IRS payment plan and stay current on payments. And always keep your IRS transcripts because that is the first thing an officer may look for if they have questions about your tax history. Because once they see a pattern of unpaid or incorrect tax filings, they can question your good moral character, delay your case, or even make a move to get your green card taken away. The next way that you can lose your green card, and one of the fastest ways to get deported, is by making a false claim to U.S. citizenship. This is one of the more serious immigration violations that we have on record. What makes it so dangerous is that many people may do so without realizing what a big offense it is. And a false claim to U.S. citizenship can happen in everyday circumstances, such as checking the U.S. citizen box on the form I-9 when you get a job, registering to vote, or actually voting in an election, applying for federal student loans as a U.S. citizen, trying to get a U.S. passport, declaring that you are a U.S. citizen to get government benefits, or using somebody else's birth certificate or passport. And under current law, it doesn't matter if you were confused, pressured, or did not understand the form. Even an unintentional claim can count, and the consequences can be extreme, including immediate placement in removal proceedings, losing your green card, permanent inadmissibility, meaning that you could never get an immigration benefit again, and possible criminal charges. And there are very few exceptions. So if you are ever filling out a form and see a box that says U.S. citizen, slow down and make sure you understand what you are marking, because even a single check mark in the wrong place can cost you your green card permanently with no chance to fix it later. And real quick, if you are enjoying this video so far, be sure to like it and to hit the subscribe button, as doing so can help more people get the information that they need, and make sure that you see more videos like this in the future. Next, if you have a 2-year conditional green card, one of the quickest ways to lose your status is by failing to file the form I-751 on time. A lot of people do not realize this, but your conditional green card cannot be renewed. Instead, you have to remove conditions. And the only time that you are allowed to do this is during the 90-day window before your card expires. If you file even 1 day late, you may automatically be considered to be out of status, and USCIS can start removal proceedings against you. There is no grace period unless you can prove one of the extraordinary circumstances applies to you, include things like a serious medical emergency, being abroad when your window opened, receiving incorrect instructions from USCIS, being a victim of abuse or extreme cruelty, or having a divorce or having your marriage end in death. If you cannot show one of these situations, then your case may get denied and you may lose your green card permanently. Now, if you are in a difficult situation, such as the fact that your marriage is not working out, you may still be able to file even after your card expires with a waiver. You can also file a waiver for situations where your marriage has ended in divorce or has been terminated due to the death of your spouse. But if you do nothing and let your conditional green card expire and do not file the I-751, USCIS may treat you like you have walked away from your residency. They can deny your case, take away your green card, and put you straight into removal proceedings. So if you have a 2-year green card, set reminders and make sure you file timely unless you need to file with a waiver, at which point you may be excused from the deadline. But if the waiver does not apply to you, this is one deadline that you do not want to miss. Another major way that you could lose your green card is if USCIS thinks that your marriage is fake. And this does not apply to people who just intentionally commit fraud. Even real couples can fall into this category if their case raises the wrong red flags. Marriage fraud is taken extremely seriously because the government sees it as a direct attempt to bypass immigration laws. If they believe that your marriage was not real or that you married only for papers, they can deny your case, take away your existing green card, place you into removal proceedings, and permanently bar you from almost every other immigration benefit. So what does USCIS look for? They look for situations like paying a U.S. citizen to marry you, marrying as a favor, a marriage where one person knows that the marriage is not real, mail order arrangements where the intent was not genuine, or cases where the couple never shared a real life together. And even if you already have your 10-year green card, USCIS can still revoke it years later if they discover evidence that the underlying marriage was not genuine. So if you are in a real marriage, don't assume that they will take your word for it. Keep good records and make sure your documents are consistent, and do not ignore notices from USCIS. And if your spouse is refusing to help, sabotaging your case, or withholding documents, talk to an immigration lawyer immediately, because that behavior can put your green card at risk far greater and far quicker than most people realize. Another way that you could lose your green card is through misrepresentation, which basically means giving false, incomplete, or misleading information to immigration in order to obtain a benefit. A lot of people think that misrepresentation only refers to big, obvious lies, but USCIS defines it much more broadly. And now they have the tools to catch inconsistencies across every application you have ever filed. Misrepresentations can include things like hiding a previous deportation or removal order, leaving out past immigration violations, lying about your employment history, using an incorrect alien number to avoid background checks, submitting documents that don't match earlier filings, or giving information that is technically true but intentionally misleading. For USCIS to accuse you of misrepresentation, two things must be true. You knowingly gave false information, and that false information was material, meaning that it helped get you approved or made the immigration officer make a decision that they would not otherwise make. If both are present, USCIS can revoke your green card even years after you receive it. And this is where things have changed in a big way. DHS's new biometric and data matching systems make it almost impossible to hide old information. They can connect your travel history, visa records, tax returns, driver's license data, and every past immigration filing in seconds. Now, to be clear, accidental mistakes are not misrepresentation. If you wrote the wrong date because you forgot or you misunderstood a question, that alone won't cost you your status. The issue is when USCIS believes the mistake was deliberate and affected the outcome of your case. Misrepresentation is also one of the hardest issues to fix. There are only limited waivers available, and most people do not qualify for them. This is why consistency matters. Every form you file should match your previous filings as closely as possible. And if you notice an old mistake, talk to an immigration attorney before you submit anything new, because correcting an old error the wrong way can make matters worse. The next one sounds almost too small to matter, but it can absolutely cost you your green card, and most people get caught by it every year, especially during the Trump administration. If you are a green card holder, you are legally required to notify USCIS within 10 days every time you move. Not the post office, not your bank, not your employer, but USCIS. And if you don't, this alone can be treated as a violation of your immigration responsibilities. Historically, this rule was not heavily enforced, but this is no longer the case. Over the past few years, USCIS has been penalizing more immigrants for failing to update their address correctly. And now that Trump is in office, the USCIS Twitter account is actively posting about this rule. So don't rush it off as unimportant. If you move, remember that you must file Form AR-11 within 10 days. You can now do it online. It's faster and more reliable than ever when you had to submit a paper copy. Just make sure that you save your confirmation page every single time. And remember, filing a change of address with USCIS does not update anything to USCIS. In fact, most immigration mail is not forwarded by the post office at all. So don't take this lightly. And this is one of the easiest mistakes to avoid, and one of the most frustrating ways to lose your green card if you fail to do it. And the last way you can lose your green card is by voluntarily abandoning it. While this sounds like something no one would ever do, thousands of people choose this option every year, sometimes without realizing the full consequences. Voluntary abandonment happens when you sign the Form I-407, which officially states that you no longer want to be a permanent resident of the United States. Once this form is submitted, your green card is gone. There is no appeal, and you cannot undo this decision later. So why might somebody do it? People give up their green cards for all sorts of reasons. They move abroad permanently, they want to avoid U.S. tax obligations, they prefer to visit the U.S. on a tourist visa rather than maintain residency, they no longer want to maintain the responsibility of filing U.S. taxes on worldwide income, or they simply feel that living abroad makes more sense for their life or career. Whatever the reason may be, the moment you formally abandon your status, you immediately become a foreign national again. This means that you may need a visa just to visit the U.S. And if you ever want a green card again, you will have to start from the very beginning of the immigration process. It's also important to understand that voluntarily abandoning your green card just doesn't affect you. It also affects your spouse or children if they receive their green card through you as well. So the rule is simple. Only abandon your green card if you are completely sure that you no longer want to live in the United States as a permanent resident, because once you give it up, you cannot get it back automatically. And for most people, getting it back is simply not easy. My name is Moumita Rahman, and I have been practicing immigration law for the past 15 years. If you would like my help on your case, you can give me a call and schedule a case evaluation at 212-248-7907. We are based in New York and serve clients all over the U.S. Now, if you are a green card holder who plans to apply for citizenship someday, then you need to understand what happens after you naturalize, because the government still has the power to take your citizenship away too. So in my other video, I break down the top 4 ways that people can get denaturalized denaturalized, the real cases where USCIS has taken away citizenship, and how to protect yourself before you apply. This is something that every green card holder needs to know, especially with the way enforcement is going right now. I'll include a link to that video here. Click now and I'll see you there.